Madam Clerk, would you open the courtroom, please? She must not be there. Let me do it then. 36th District Court is now in session. Judge David Robinson is presiding. We are calling for pretrial case number 20157-986, Citibank versus Dolores Farrell. Let me have your respective appearances.
Craig Fay for plaintiff P814001.
Greg Fisher for Dolores Farrell, P80885.
All right, gentlemen, we were last together on this. The court denied a motion for summary disposition, finding there to be a genuine issue of material fact on the amount of money that was due here. Where are we on this file?
As of today, we haven't been able to resolve it. I'm not sure if Mr. Fisher has any.
We are looking to resolve it. There are, Ms. Farrow has 2 other collection suits going against her. So right now we're trying to piece things all together as far as her resources to settle this. So plaintiff has invited us to make an offer to settle, and so it's in process. We do want to settle it. And certainly if they have an offer to make to us, you know, I'll take it to Ms. Farrow.
Well, I'm sure if they're waiting for an offer from you, they're not going to bid against themselves. All right, I'll give you another day, gentlemen. We'll have to return on this file. The next day will be May 5 at 10 o'clock. Does that work for everybody?
That works for plaintiff.
I believe that works. I have to be in front of Judge Ewell at 11:30 on the 5th.
Well, I was going to do this at 10 o'clock.
Okay, that works.
You have to be physically present?
No, I don't believe so.
Okay, I don't think anybody's doing much physically these days.
Okay, all right, yeah, that's fine, Your Honor. And I'll be on time. I'm sorry.
Okay, May 5, 2021, at 10 o'clock will be our next pretrial. Is there anything else we should accomplish today, gentlemen?
No, Your Honor.
No, Your Honor.
So we'll send you out a notice. We'll see you May 5 on Zoom at 10 o'clock. Thank you for coming.
Very much.
Thank you.
Record. We are on the record calling file number 201649998 Jefferson Capital System versus Tanisha Hines. By notice dated March 17th, this matter is scheduled for pretrial today, 10 o'clock. It's currently 10:31. Your appearance.
Yes, Your Honor. Ian Childs for the plaintiff, P84969.
All right, Mr. Childs, have you heard from the other side?
I have not, Your Honor.
All right, let me read into the record something that was, have you seen the answer?
Yes, I don't see any denial of owing the debt, Your Honor.
Okay, so you have the answer.
Let me make sure that this was an answer.
It's headed, this letter is regarding a summons.
Yes, I apologize, Your Honor. I don't have it readily available. Let's see, complaint. Your Honor, I do not have an answer.
All right, let me read to you the answer, and I'll have my clerk send a copy along to you. My name is Capuchin Williams. I'm the mother of Tanisha Hines. Tanisha's address is the Lothrop Street address that the court has been using. Letter continues. Tanisha is not mentally able to respond to the summons. She is currently in the hospital in the psychiatric ward. She is confused, wandering, mentally unstable, and can in no way answer the summons. She is low income, is not working, and in no way be able to do anything about this old bill. Please excuse her from coming. We don't know how long she will need care. We will be moving her to a better facility. I also sent a letter to the hospital signed her mother dated March 5th. Upon receipt of that, I set the matter for pretrial today. We don't have an appearance from the defendant. Frankly, we really don't have an answer by the defendant. We have an answer by her mother. But her mother has failed to appear. There's no indication that any court has declared the defendant to be mentally incompetent. So what do you want to do here?
Your Honor, I would move to enter a default judgment.
All right, the court is going to enter the default here. No appearance having been had. I look forward to your proposed default judgment, sir.
Thank you, Your Honor.
Have a good day.
Yeah.
We're off the record. Good morning, gentlemen.
Good morning, Judge.
We are on the record. We are calling case number 2016856, Tasha Norwood versus Travelers Indemnity. Your respective appearances.
Good morning, Your Honor. Richard Brewer, P31124, on behalf of plaintiff.
Good morning, Your Honor. Ross Brunetti, P7080, on behalf of defendant.
All right. I have and will be sending out today to you, gentlemen. I didn't send it because I wasn't sure whether you would get it in time. Do you have the order striking defendants interrogatories and stipulated order for 60 days of discovery? Have that you received those things?
I believe so, Your Honor.
You have
Yes, Your
those
Honor.
already?
Yep.
Okay, so I don't have to worry about that. So where are we on this file, gentlemen?
Well, Your Honor, we've discussed plaintiff's initial disclosures. One of the billings is going to be removed because one of the providers is representing those billings themselves in another separate action. Mr. Brewer has agreed to a limited deposition of his client, Ms. Norwood, not to exceed half an hour in length, so that we can obtain proofs for the replacement services and potential wage loss claims. So we would ask that you adjourn the state or provide another date. I would say 45 days down the road so that we have time to get the proofs that we need to hopefully wrap this one up.
Okay, so all you really need, and correct me if I'm wrong, is Mr. Brewer is going to file a pleading striking portion of his claim, and then you need the half-hour deposition of the injured person, correct?
That is correct.
Okay. Can we get that done by May 5th?
I know that we've scheduled the deposition of Miss Norwood. Let me just pull up to see when that is going. Actually, I don't see that notice of deposition yet. I know that we were talking about dates. Richard, do you have a date for her?
Like you, I am not the keeper of my calendar. I would have to check with she who must be obeyed.
I know, and that's my secretary too. I know that she has been communicating with your office to work out a date. I thought it had been picked, but apparently it has not been picked yet.
Well,
We'll get her done.
okay, here's what I'll do. I'll give you a return date of May 5, and hopefully by that time we'll be positioned, if we have not done the deposition, we certainly will be in position to know when it's going to be done. And Mr. Brewer's pleading adjustments should be accomplished by that time as well.
Yes, Your Honor.
Is there anything that day work for both of you? May 5 at 11, like today?
That works for me, Your Honor.
Let me just check the
Yeah,
current calendar, Judge.
yeah, I understand.
May. What time would that be, Judge?
11 o'clock like today.
Yes, that would work for me.
All right, so what I'll simply do is I will give you another date, May 5 at 11 o'clock. In the meantime, let's get these this little procedural matter done. And if we cannot get the deposition accomplished, at least get to a point where we know when that deposition will be taken.
Yes, Your Honor.
Is there anything else we can accomplish today?
I don't think so.
I have nothing, Your Honor.
Okay. I have a secret for you. When I came to the bench, I'd been in private practice for a couple of days, and I thought I'd be escaping she who must be obeyed. All I did was get another one.
I think that's our lot in life, Judge.
I think that's true. Y'all have a good day and be safe. May 5 at 11 o'clock.
Thank you, Your Honor.
Your Honor.
Thank you, gentlemen. right. All right, let's see what we have here. Ms. Strickhart, good morning.
Good morning, Your Honor. How are you today?
I'm good. How are you?
I'm okay.
What brings you here?
Well, Judge, I have three cases before you today.
You're the Midland funding?
Yeah, I've got a Midland v. Sane, a Jefferson v. Hutchinson, and a Jefferson v. Johnson. And these are all motions to set aside dismissal and enter default judgments where we never got notices of intent to dismiss.
Okay. I don't have an opponent for you yet, so you're off to the waiting room.
Okay.
Oh, there you are. Ms. Brandy, what brings you here today?
Your Honor, this is the plaintiff's motion to reinstate on Christina Williamston versus Otis Culpepper. I represent the defendant in this matter. I'm responding to the motion to reinstate.
Got you. I don't have an opponent for you yet, so you're off to the waiting room as well.
All right, thank you.
Mr. Johnston, what brings you here today?
Good morning, Your Honor. This is plaintiff's motion to reinstate One Detroit Credit Union versus China Hardville.
Okay, I don't have an opponent for you yet, so you are off to my waiting room as well.
Okay, thank you, Judge.
8:43. Six, six, six. Schumer side, didn't it? What do you have to do? Let's call Miss Brandy's case. We are on the record calling file number 19183-178, Angelina Miller versus William Otis Culpepper. By a notice dated March 17th, 2021, this matter is scheduled for hearing today, April the 14th at 11 o'clock on the plaintiff's motion to reinstate the case. It's now 11:31. Plaintiff has failed to appear. Your appearance, counsel.
Good morning, Your Honor. Brunetta Brandy, representing the defendant W. Otis Culpepper in this matter.
Counsel, plaintiff has failed to appear. No good call of that failure having been shown. Plaintiff's motion to reinstate the case is denied. We'll send you out a copy of the order.
Thank you, Your Honor.
Thank you. Enjoy your day. Be safe.
You as well, Your Honor.
Thank you.
Thank you.
All right, Mr. Johnstone, what case are you here for, sir?
Your Honor, this is
One
case number,
Detroit Credit?
yeah, One Detroit Credit Union.
Okay. I thought that was it. We are on the record. We are calling case number 201655554. One Detroit Credit Union versus China Hardville. By a notice dated March 17th, 2021, this matter is scheduled for hearing today, April the 14th at 11 o'clock on the motion filed on behalf of the plaintiff to both reinstate the case and to enter a default judgment. This matter is calendared for 11 o'clock. It's currently 11:32. Your appearance, sir.
Good morning, Your Honor. Andrew Johnston, P79752, on behalf of the plaintiff.
Sir, we don't have a defendant here. Your motion, if you would.
Thank you, Judge. Your Honor, this case was filed on October 21st, 2020. Defendant was personally served on January 12th, 2021, so before 90 days, within 90 days of the summons being issued. We received a notice of dismissal. Notice of dismissal was dated February 11th, so less than 30 days after we had personally served defendant. So, Your Honor, I would ask that the court reinstate this case pursuant to MCR 2.502C.
Counsel, I've had a chance to review the file here. It appears that you have a proof of service indicating that the defendant was personally served on January 12th, 2021, which is, of course, less than 91 days from the date that the summons and complaint were issued in this matter. You appear to be entitled to your default judgment. Your motion to reinstate the case and enter default judgment, which I know for the record is unopposed, will be granted. We'll send you out your paperwork today, sir. Have a good day, and thank you for coming in.
Great, thank you, Judge. And just for the record, does Your Honor have a copy of the default judgment? Or
Yeah, there was a default judgment that accompanied your motion.
Okay, great. Thank you, Judge.
All set on it. Thank you, sir.
Thank you.
Have a good day.
You as well.
All righty. We are on the record with Ms. Rickards, who has a number of matters with us today. Let us begin with case number 18184-3. This case is entitled Jefferson Capital System versus Kyle Sane. By a notice dated May 23rd, this matter is before the court today, April 14th, on plaintiff's motion to set aside the dismissal and enter the default judgment. This matter is calendared for 11 o'clock. It's currently 11:35. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, STRICHARTZ P44018 on behalf of the plaintiff.
Mr. Rickards, I don't have a defendant here. Would you proceed with your motion?
Thank you, Judge. Yes, we filed this motion to set aside the dismissal and to enter a default judgment. Service was perfected before the summons expired, Judge. We submitted a default judgment to the court on September 11th. We do not have a copy of it. This is part of a batch that was submitted to the court on September 11th. We've done a bunch of motions on these because for some reason they weren't on the ROA and they weren't apparently processed and nobody can find them and nobody knows anything. In any event, Judge, we did not receive a notice of intent to dismiss on this one, obviously, which would have triggered us for an aggressive follow-up, but be that as it may, service was perfected within the time on the summons. We are asking the court to set aside the dismissal and enter that default judgment.
Court has had an opportunity to review the file. You appear to be entitled to the relief which you are seeking. Service was made in a timely fashion. Here, no action was made. The unopposed motion to set aside the dismissal and enter a default judgment in this matter will be granted.
Thank you, Judge. We do have a proposed order and a proposed default judgment at the back of the motion. The last maybe four pages or 5 pages from the back. There's an order set aside and
I got it.
you got it.
Okay, let's move on to your next case. This is file number 19182-585, Jefferson Capital System versus Mondo Johnson. In this matter, we have a plaintiff's motion to set aside dismissal and enter default judgment. By notice dated March 23rd, this matter is scheduled for hearing today, April 14th at 11 o'clock. It's now 11:37. We have no appearance by the defendant. Your motion, your appearance.
Good morning again, Your Honor. Suzanne Strickards, P44018 on behalf of the plaintiff. This is our motion to set aside the dismissal and enter the default judgment. In this case, Judge, we did have service perfected before the summons expired. We did submit as proposed default judgment on September 11th of 2020 for some unbeknownst reason. It's not reflected on the ROA. We don't have our timestamp copy. We did not receive a notice of intent to dismiss on this one, Judge. Obviously, that would have triggered further inquiry on our end, and we are asking for the dismissal to be set aside and the default judgment to be entered.
Counsel, the court's had an opportunity to review the file. You appear to be entitled to the relief that was granted, given the fact that service wasn't being made in a timely fashion. The defendant has failed to appear. The unopposed motion to set aside the default, the dismissal and enter the default judgment will therefore be granted.
Thank you, Your Honor.
And your final case, Jefferson Capital System versus Daria Hutchinson, which is 20147-666. By a notice dated March 23rd, 2021. This matter is scheduled for hearing today, April 11th at 11 o'clock on the plaintiff's motion to set aside dismissal and enter default judgment. Although calendared for 11 o'clock, it's currently 11:39. I have no appearance from the defendant. If you would, counsel.
Yes, good morning again, Your Honor. Suzanne Strickards, P44018 on behalf of the plaintiff. Your Honor, in this matter, we do believe that service was properly made before the expiration of the summons. We did not receive a notice of intent to dismiss. We did submit a default judgment on September 11, 2020 that is not reflected on the ROA. We do not have a timestamp copy. And we are asking that the dismissal be set aside and a default judgment enter.
I've had an opportunity to review the file, your unopposed motion to set aside the dismissal, the enter default judgment is granted. It appears that the defendant was timely served prior to the expiration of the summons. He failed to answer. We'll send out orders. I think that concludes your call today.
Thank you, Judge. Yes, every file has an order and the proposed judgment.
Yes, I've seen that, and we'll enter both the order and the proposed default judgment on all three of these files.
Okay, thank you, Judge. Have a good day.
You can do the same.
Bye now.
Take care, be safe.
You too.